First item on the agenda has, we have a list of quite a few people that want to speak on the issue. Because of time limitations, we're going to limit additional comments to 3 minutes per person. However, Ms. Lamandre and Senator Mizell, as they are both requesting, or at least her representatives here in her place, I think.
Senator Mizell is not here at this time, or is not going to appear today. However, I've been informed that Representative Beryl Amadi will be appearing, that she was going to be a little late, but once she arrives, I will let the board know that as well.
But since she requested a rehearing also, we'll
correct.
Give her additional time. Welcome. Please introduce yourself and tell us your name and so forth.
Yes. Morgan Lamandre. I am a candidate for House District 66. Most of you were here the last time I appeared in November. I requested an advisory opinion asking if I could use campaign funds for child care expenses that would be incurred only as a result of campaign activities and events. What I meant by that was that but for those events, I would not need the child care. In my request for reconsideration, after hearing that there were concerns from the board, certain board members about the specificity and what kind of events or activities, I made a list in the page 2 of my request, if you have it before you, where I sort of talk about the particular activities I would potentially need childcare for. And in that I said debates, panels, fundraisers, and canvassing. And those types of events usually occur outside of the normal business hours, which I already have childcare available. I already pay for that with my own personal funds because that is not part of my campaign. The last time I was here before you, in the end, what I realized from the recording is that ultimately it sounded like you guys didn't rule on that issue. Some of you had concerns about whether or not it was specific, but ultimately the opinion that was issued just outright stated that campaign funds used for child care expenses is not allowed because it is a personal expense or personal use. And so rather than just saying, oh, please come back or give us a little bit more specifics, the actual advisory opinion that was issued just outright prohibited it. So I submitted a request for reconsideration because I believe some of you were not wanting to rule that it was a personal use, but that it was more, you needed more information about what that would look like. I know that some of you, basically people come before you because maybe they've done something unethical. And so by saying campaign events and activities, I know as somebody who has integrity what that looks like. But I understand that maybe for you all, you wanted sort of a list of specific things. So as I said, in my request for reconsideration, I have the specific things that I would be looking to use campaign funds for child care expenses. But I'm here before you to try to obviously get an advisory opinion that would be fair, that would allow working parents to be able to run for office that are not necessarily independently wealthy. If there's any other questions right now, I'm happy to discuss.
And I agree with you. Your original opinion was find out what circumstances, if any, may child care expenses be paid out of campaign funds, which is a pretty wide open question affecting not only you but anybody else making that inquiry. Our job, or at least our task, is to respond to requests for advisory opinions, and generally they have specific questions that they're asking about themselves, not in general. And I think that what happened was the opinion when it was finally drafted by the staff, perhaps doesn't quite reflect what your questions were. But the problem is your question was so general that it's impossible to answer. With your specifics, it might be easier to come up with a solution. It certainly wasn't a male-female issue. The prior request by Mr. Warso, he asked 3 specific instances. Could I use my campaign funds for these specific items? And that board 20 years ago told him that he could. There was also an entry by Mr. Kennedy in his campaign report. He didn't ask for an opinion, he just filed his campaign funds or his campaign reports, and he reported on one occasion he hired a babysitter for a campaign event. So that being said, any questions, any comments by the board?
And I know that gender wasn't specifically mentioned at the last hearing. I think what kind of blew up was certain specific things that were said about misplaced priorities for raising money or to use campaign funds for that purpose, and that having a child is my primary responsibility. It was charged comments that it didn't have to say anything about my gender. It was implied, and I think that is why you saw so much attention to it, because there were more men that have used it, and although they didn't request an advisory opinion, as recently as 2013, Joel Bowie had used campaign funds for childcare expenses. So although nothing about gender was mentioned, the overall circumstances certainly looked a lot like gender was an issue. But I appreciate you commenting and saying that it wasn't. I'm glad to know that.
I suspect if someone combed through all of the campaign filings over the many years and looked at all the entries, probably there'll be many instances where child care was listed and paid. So
I combed through all of the ones that were not scanned, and I've only seen the ones expended by males for child care. So
really? Okay.
Yes, but not the scanned reports, because those you can't really enter various terms like babysitter, child care, different care. And I did notice that there's a lot of other care that's used: lawn care, car care, various types of office care. So I did find that it was very interesting that certain types of other care was allowed in the expense reports, but just not child care.
So part of our difficulty is that under the FEC law, they rule on whole categories as personal expenses and therefore not allowed. But we don't have a definition of personal that follows the irrespective test, right? If you read our appeal, we don't even have a definition of personal. And so then we have to have circumstantial details so that we can decide what's related or not. And that's the difficulty. The FEC rules on categories. If it passes the irrespective test, it is a campaign expense and non-personal. If it's personal, it's not allowed. For us, it's a little bit muddier because some personal expenses are allowed, although we don't have a definition of what counts as personal, and those that are related are allowed. And so, I mean, that's the difficulty with which we were dealing last time, is trying to specify to what degree of related should we allow.
Right, which 2 points to that. I do believe that there may finally be some specificity after this current legislative session. But the other thing that I thought was quite interesting is that we don't have the irrespective test. But in the holding from the First Circuit, which you're not bound by your own precedent, but you're bound by the First Circuit, I thought it was interesting that one of the arguments of the board in trying to sort of say that Mayor Kip Holton had used these expenses for personal use, the board used the irrespective test. And I just thought that that was actually kind of interesting. So it sounds like it, yes, we don't have it written in our law to use the irrespective test, but it was interesting that when it did benefit the board, or potentially benefit the board, the test was used.
Yeah, and if we use the irrespective test, our law actually becomes extremely permissive. Because if we use the irrespective test to define what counts as a personal, then some expenses you would have had irrespective of your candidacy are now allowed, those that are related. So our law actually becomes much more permissive than the FEC, which is in your favor.
Right. And I think it comes down to, is this a lawful purpose? Childcare is a lawful purpose. And is this related to my campaign? It's absolutely only related to my campaign. This is not going to be used unless it's related to my campaign. And like I said, I mean, whether it means although I'm not the most organized person, I am the most ethical person. And whether it's me attaching to the reports, although I don't know that there's a way to attach them to the reports. I know mine's due today. I'll be sure to get that in on time. But whether it's like a campaign flyer event, or I mean, whatever has to happen in order for it to be properly documented, that will be done. You will be able to check to make sure that I am not using this for any personal actual use. This is not, as was brought up last time, this will not be date night. This will not be if I'm in a restaurant and somebody comes up to me and says, hey, let me ask you a question. That's not how that works. That's not how that works. It would be prior, it would be something that was planned, something, you know, and I get that not everything is completely planned. I mean, canvassing could be at any moment, but it's going to be something that is completely, unequivocally related to my campaign and to solicit, to get votes, to get donations. It's only going to be related to my campaign.
Has Louisiana law changed since you were last here? Has the law applicable to the use of campaign funds changed?
So because our legislature only goes in session either in March or April.
Exactly.
Yeah.
So it hasn't changed, right?
No.
Okay. So you referenced the FEC case when you were last here. Do you realize that the facts in that case are tremendously different from the facts that you have?
Mm-hmm.
In that case, the candidate was a stay-at-home mother who did not require child care. When she did need child care to work, after her mother got off work at 3:30, her mother cared for the children and did not charge her. Now, regarding the irrespective test, according to the FEC, that is the idea that the campaigns cannot spend money on things that would exist irrespective or regardless of the candidate's campaign or responsibilities as a federal office holder. Are you running for federal office?
I am not.
Okay.
That's why I'm before you. But
Okay,
it's interesting.
so-
Did you see in your packet the
Hold
letter
on a
from
second.
Lupa
Could you
Director
just answer my question?
Absolutely.
Are you running for federal office?
No, I'm not.
Okay, so that part of the irrespective test as applied by FEC does not apply in this matter. Now, irrespective, go back to the first part of that. The campaigns cannot spend money on things that would exist irrespective or regardless of a candidate's campaign. In this case, and you stated again this morning, you already pay for child care. You pay for after-school care, correct?
Yes.
Okay, so you would have that cost for child care anyway, regardless or irrespective of your run for this office.
I think
correct?
you're misconfusing the
No,
issues.
hold on a second. Hold on a second. Because what you told us when you were last here, you made it a point to say that we should follow the FEC case. And as a lawyer, you understand that it's not just, you can't just blanket apply a law without looking at all of your facts, right?
Can I respond to your question?
Hold on a second. Yeah, that's the question. Can you just simply apply a law without looking at the facts? Because according to the way we practice law, just because there is a law doesn't necessarily is going to apply to your factual situation. So my question to you is, since you've stated that you already pay for child care, you pay for after-school care, why should we believe that your facts are the same as the FEC case's facts, in that regardless of whether or not you're running for office, you should be allowed to apply to use your campaign funds when you already have that expense? That is already a use. So if you were to use your campaign funds to pay for child care, which you would already pay for, why wouldn't that be a personal benefit to you?
So a few things. First, last time I was here, we referenced the FEC opinion. I know the difference between federal guidelines and state guidelines, which is why I'm before you. So I didn't say that I actually believe it was the board member who mentioned the FEC and following the FEC, to which Mr. Bruno jokingly said he didn't believe the feds were all in our lives that much yet. I did not say that. The second point I'll make about that is you're confusing the issues. I already have childcare that is paid for by my personal funds. I would need additional childcare. Childcare on weekends, childcare on nights. That is not the same thing as what you're referencing. So yes, we have to apply Louisiana law, which Louisiana law states that it has to be not for personal use unrelated to your campaign. So before you is facts presented for Louisiana law. No one's saying that you have to use the FEC guidelines. I'm actually saying use Louisiana law, use what has been done previously multiple times, and that is what I'm saying.
And I'm glad you said that to you, that we should use Louisiana law, because in the Holden case that you mentioned, as you know, the board actually lost that case, and the district court, along with the First Circuit, said that the funds that Mayor Holden wanted to use, the campaign funds that he wanted to use for his constituents, was not for his personal benefit. Paying for a funeral does not personally benefit him. Someone mentioned, I think it was you or someone else mentioned at the last meeting, well, you allow the purchase of Mardi Gras beads. That's not considered part of for the candidate's personal use. My concern is paying for child care. Who personally benefits from that use of child care?
So as far as the child care goes, if it was commingling to where it was somehow paying for child care that I already had, then yes, it would benefit me. But that's not what I'm asking. What I'm asking for is child care that is, it's no different if I hired somebody for my campaign who happened, I could easily hire somebody for my campaign as a campaign manager, and if unrelated, not during working hours, they were like watching my child, that would count. But for times, not while they're actually in school, not while they're actually having childcare that they already have. That's not what I'm asking. So there isn't a personal benefit because I wouldn't need it except for the campaign. So it's not a personal use. It's not a personal benefit to me. If anything, if you look at the chart that was provided online about all the different expenditures, there was one where somebody commingled sort of their personal cell phone use where they could use campaign funds to pay for part of what is to me, that's more of a personal use or personal benefit, because the benefit of their cell phone, that is actually going in, you're not prorating which calls were for the campaign versus not. That is more commingling than what I'm doing, which is completely unrelated to what I already have.
And that brings me back to my original question to you. Has the Louisiana legislature changed the law since you were last here? We're going to run into the same situation today, I believe, at least as far as I'm concerned, as we did when you were last here. In the Holden case, there was a concurring opinion from Judge Klein who actually said, I concur only to respectfully express that the statutory language in Louisiana Revised Statute 1505.2 I-1 would better serve candidates, office holders, and the Louisiana Board of Ethics if it included more exact standards.
I agree with that.
Okay, so my point is we're not a lawmaking body.
You're not.
Okay, so we can only apply the law to the facts as they are presented to us. Mm-hmm. And I can't speak for the entire board, but as far as the facts are as I see them and as the law is currently written, I do not see how we can or how I can agree that child care can be included under this body of law. Now, when you were here before, I believe I said it, other members said it. If you disagree with us, please, by all means, go to the legislature. Go to the courts if you have to. But if the law does not change, I don't see where, again, from my perspective, my position doesn't change.
I think, though, a couple of things to that. Louisiana already has so many fiscal crises. Why would you want me to take it to court where ultimately, very easily, the board, the state would have to pay attorney's fees and funds? Nobody has time for something that clearly on its face, even in 2000 when Daryl Orzo had his opinion, at least for category number 1, where he requested fundraisers for his own candidacy. That is clearly the same thing. And I think that if you go and I take it before court, it will look very, very strange, no matter what, even though gender is not mentioned, that he was allowed to do it, a male candidate as recent as 2013 was allowed to do it, but now all of a sudden we're raising some issues about it.
No, actually, Ms. Lamandre, you did raise the issue. Maybe not in here necessarily, but you have raised the issue and about it being gender. And for me, it was not gender related. It was strictly an issue related matter. And what I take issue with being characterized as someone who in any way is against female empowerment. And that is what has been portrayed. Now, if you want to be fair in this, you will appreciate the position that we are in as the board. We are left with a law in the past, it has been suggested by the court that that law be amended. In 6 years, it hasn't been amended. And I find it quite odd that now, all of a sudden, there are members of the legislature who now see the need to do this. I'm glad they see it now. But this was not the first time this issue had arisen. So I'm hoping that in their infinite wisdom, that they do decide to amend the law, and it will make it a lot easier for the board to render opinions based upon the law as it is written. One of the things that I hope that they include in the law is, whether or not a personal style consultant can be used for. We can use campaign funds to take care of a style consultant. We get hit with that all the time. So I think it would be great if they could itemize what's considered an appropriate use of campaign funds. We would definitely appreciate that. Thank you.
I have a question for you. In my mind, it seems I agree that the law is ambiguous because we don't have a definition of personal or related. But if we follow the guidance of I think it was the First Circuit, it says that we have to, since we don't have a definition of personal use or related, we should construe it in the broadest sense. So that's currently the kind of interpretive guidance we have for construing this law. And I think under the broadest sense of related, or maybe even a more narrow sense, this is related.
And that was the concern that we had at the last meeting. How broad is broad?
Right.
And so I think it would definitely help. You all can do what you want to do. But as far as I'm concerned, I would feel more comfortable if there was an actual delineation of at least some definition or explanation of certain terms, such as personal use, related use. Have it in the federal government and the CFRs. Why not put it in the Louisiana revised statutes? So until that is done, we're going to run into the same problem over and over again until the legislature amends the law and provides those specific definitions or explanations that will provide adequate guidance for this board.
Right.
That is the body that can do that. We can't do that.
Well, should Mrs. Lamandre be successful in her candidacy, we as a board every year
That'll be a perfect bill, first bill.
present we present requests to the legislature all the time for assistance precisely along these lines. So we may have a new champion for us that we can go to and request legislation to be introduced.
And Representative Beryl Amity, and in connection with Senator Mizell's submission of reconsideration, has arrived, so she's here as well.
All right. Any other board members with comments, questions?
Just to comment, I've served on this board for 9 years, and we have spent a lot of time over the years wrestling with this ambiguity. So we would also enjoy some clarification.
Representative,
Yes.
please introduce yourself.
Thank you, sir. Good morning. I'm Representative Beryl Amade, and I'm here on behalf of Senator Beth Mizell, speaking for the Legislative Women's Caucus. I do apologize for walking in after the meeting has begun, but pray for me. I drive on I-10, and I just wanted to come this morning to let you know that the Legislative Women's Caucus requested that this be reconsidered, not because it's a male or female issue, but because in the past, this same question has been decided by this body in favor when a male candidate or elected official requested it. Therefore, we felt it deserved another opportunity for discussion. Thank you.
Thank you. Any questions for?
I have one. I have a response to that, and that brings me to another question that I had. That if there were an opinion already in place that apparently in some way or at least slightly addressed the issue that is currently before us, why was that opinion not sufficient?
I'm not familiar with the opinion that was requested more recently. I came in after the fact, hearing about it after
2000 opinion that you mentioned.
Oh, I thought you meant the recent one. Could you state your question again? I'm sorry.
I think the question is why do we need an opinion if we already have one?
Right, which Ms. Lang, she was the one who was assigned originally to the case, she told me about a week or so before the last appearance, hey, it turns out there's already an opinion. Now, I'm more familiar with the Ethics Board website now, but at the time when I was looking around for an opinion or anything that would address this, I did not find one. It was not until Ms. Lang had told me, and when I asked her, well, should I withdraw the request? She said no, because it would be easy to get it through since there was a previous opinion granting it, and I would actually have to ask for in the form of a written permission to withdraw my opinion. So that's why we didn't.
You were told it would be easier to get it through?
Well, she didn't say that. I want to be careful about that. What she said was, hey, there's already an opinion that addresses this, so I don't foresee any problems.
And had you explained your factual situation to her?
Yes, she actually sent me a draft opinion ruling in my favor, which was posted to the website and available for everyone. She had to rewrite her opinion. And I don't want this to be something that as if it was all very, very, before the staff, before the board, it was very clear at that point that it just looked like the same sort of request, especially under the Category 1.
Well, it wasn't, because it was just a request, what can anybody do with campaign funds, just basically. So it was very wide open, where the other one, as I said earlier, was specific. However, I think we understand your point. Ms. Deborah, would you call in order of people that have appeared, that have listed on the requesting an appearance? And
okay, it looks like the
if
next.
they'd like to say something.
Sure, Mr. Franz Borgart.
My name is Franz Borgart. I've lived in Louisiana for over 40 years. I'm a civil rights attorney and I practice in Baton Rouge. And to be brief, I'm here to talk about consistency. As someone who does not do a lot of work before the ethics board, you might imagine my confusion in listening to some of the things that I'm hearing, because it sounds like in one breath, she might be able to do what she wants to do, but I'm hearing that maybe she can't. I've read the First Circuit opinion. It seems very clear to me that she probably can do what she's trying to do. And I think it should be noted that she did the right thing. She's standing before you or sitting before you, asking for your opinion, your advice. There's something, and I will emphasize that I agree. You are not a federal entity. This is a state entity. But everybody in this room is bound by a constitution. And the pillar of that constitution is treating everybody the same way. We call it the Equal Protection Clause. We sometimes call it due process. We like it when people call balls and strikes consistently. We like it when the flag gets thrown when there's clear penalty on the field. And that being said, I would urge this board to be consistent. I would urge this board, and I was very thrilled to hear it's not an issue of men or women, and it's not an issue about not wanting to see someone empowered, but from the outside looking in, the optics sure do look differently. And I don't say that just as a civil rights attorney. I say that as a citizen looking from the outside in. So I would urge each and every one of you, you're not bound by your prior decisions, and you're not a legislative entity that makes law, but when you don't uphold your prior decisions, it sure does leave a lot of chaos for the rest of us out there trying to do the right thing, trying to abide by the law, and trying not to run afoul of the ethics rules. I support Morgan's request. I support a request to be able to do that which other men have been allowed to do in this state. I think that's a reasonable request, and I think she's going about it the right way. And I hope that the legislature fixes this issue, but in the meantime, she should be able to use campaign funds, not for personal purposes, but for campaign purposes. And as a parent that has a child, I think that that's a reasonable request. I would thank you guys for the opportunity to speak and hope that you do the right thing. Thank you.
Thank you, sir. Okay, we'll call the next one.
Yes. Yigal Bander.
Please introduce yourself, sir.
Good morning. My name is Yigal Bander. I live and practice law in Baton Rouge. I'm also a husband, the father of 4 daughters, and the grandfather of 2 boys. I would like to explain why Dr. Miner is exactly right on the law. I know something about the law. I'm not talking federal, I'm not talking constitutional, I'm talking the Louisiana statute, LARS 18:1505.2D1. What it says is that a candidate can expend campaign contributions, quote, for any lawful purpose. We all agree childcare is a lawful purpose, but such funds shall not be used. And then this is very important, quote, for any personal use unrelated to a political campaign. It does not forbid a personal benefit. It does not forbid personal use. It forbids, quote, personal use unrelated to a political campaign. Words in a statute are all there for a reason. If the legislature is saying personal use unrelated to a political campaign is what we forbid. That should be clear. Child care, additional child care, evenings and weekends, that is for the sole purpose of allowing a candidate to attend campaign functions with her spouse, may be personal use, but it is personal use related to a political campaign. And if there is any doubt, any uncertainty, any ambiguity, then Dr. Meinert, again, is exactly right on the law, that the First Circuit in the Holden case made it very clear that because violations of the CFDA can result in the assessment of a civil penalty, the statute is penal in nature and must be construed in favor of the candidate and against restrictions or penalties on the candidate. That is the law. That is Louisiana statutory law with guidance from the First Circuit and a writ denial from the Supreme Court.
Thank you, sir. Your time's up. Just over next one.
Nicole Bauer.
Thank you. I'm Dr. Nicole Bauer. I'm a political science professor at LSU, and I study the barriers that limit women's representation, especially in the state of Louisiana. And I appreciate the board's attempt to look at this issue as one that does not disproportionately affect women. But that is a fallacy. Childcare and the expenses and activities accrued with it is indeed an activity that not only disproportionately affects women, but it is a barrier that limits women's access to political participation and limits women's political representation, especially in the state of Louisiana, where I'm not sure if you're aware, Louisiana ranks 47th out of 50 in women's representation. We are winning the race to the bottom. And a board's decision that creates additional barriers that makes it more difficult for women to run for and pursue political office at the state level and at lower levels can have a dangerous and chilling effect on the ability and the willingness for women to be able to pursue political office. And so I would urge the board to think about that when it makes this decision. Certainly, men and women and fathers and mothers participate in taking care of children, but it is inherently by the virtue of the fact that women give birth and the social expectations that are placed upon women, an activity that disproportionately affects women, and it should not rule out their participation in public life. Thank you.
Thank you, Dr. Brown. Kevin?
Mary Patricia Ray.
Mary Patricia Ray.
She's coming.
I'd appreciate it if you don't start my 3 minutes till I actually get there. Thank you. Hello, my name is Mary Patricia Ray. Many of you know that I serve as the communications director on John Bel Edwards' successful campaign for governor, and that I'm a campaign consultant. I'm sorry that you can't hear me too. It would be great to have some babysitters right now. And I think you may have caught on to the fact that that's kind of the point of me bringing my son Henry Lee here today. I gave up 3 years of my life to elect our governor, and I put off having a child during that time, which was my choice. It was my choice to do so. But many of you have heard the comments that were made at the last meeting, that we all make choices and having a child is one of them. I choose to appear before you today because it's very important to me that my son Henry Lee know that I'm not sorry that I'm his mother. I won't apologize for it, and there is no reason that the current law cannot be interpreted to accommodate a reasonable campaign expense. I assure you, caring for an 18-month-old while a campaign event's going on at 8 p.m., which is a normal thing to happen in a campaign, is very, very reasonable. It's very able to be regulated, it's very able to be monitored, and you could do it. The women of this state need you to do it, They really need you to do it. I grew up in a culture of family-run campaigns in my home state of Ohio, and I've been very lucky to serve many men who have been elected to office here in Louisiana who had families of their own. The culture of family-run campaigns improves our democracy. Putting real people in office improves our democracy. We need you to improve our democracy by ending decisions like this that send a very clear signal to would-be female candidates. It is very clear. As a graduate of a Louisiana law school, I know there is no reason that this board and commission system that we have cannot interpret the laws on the books in a meaningful way that does not, on purpose or on accident, discriminate against women running for office. It's possible. I hope that my son one day will know that I came here today and I didn't sit silently, that I spoke up because I'm not sorry that I'm his mother, and I'm tired of my government asking me to be. Thank you.
Thank you, Ms. Wright.
By the way, he just said mom for the first time last night, so it's a great Valentine's Day.
And I'll state that all emails that were received by our office prior to the meeting have been provided to the board as well.
Which was quite a number.
Right, and included Ms. Rice.
Belinda Davis.
Good morning. My name is Belinda Davis. I'm a resident of Baton Rouge, the mother of 3 children. Louisiana is consistently rated one of the worst states for working mothers in the country. I am one of those working mothers. 10 years ago, I was approached about running for my local school board, and I said no, because at the time I had a 1-year-old and I did not know how my husband and I would meet the financial obligations associated with child care costs while I campaigned on the weekend and while my husband was a junior partner at a law firm just starting his career. It has been raised that the legislature should address the lack of specificity in the law. I would like to offer a hypothesis, because I'm a political science professor, that one of the reasons the legislature has not addressed this issue is because we have so few women in the legislature with young children. And it is not a pressing matter for them because women are not being elected to office at the same rates as they are in other states. And so as a future candidate for political office in our state, I would like to see you consider the decisions that were made by previous boards in the favor of male candidates being able to use childcare as a campaign expense, and they were not fined for it. And I would like for you to please carefully reconsider your opinion. I know that you are not bound by precedent, and you should not necessarily be impacted by public opinion. I'm asking that female requests be treated in the same way as all other requests. That's it. Previous candidates have filed campaign statements with child care being covered. We're just asking that we be treated the same way now and in the future. This doesn't have to be a gender thing. I absolutely agree with you on that, and it should not be. Every request for this type of care should be covered in the same manner. Thank you for considering Ms. Lamandre's reconsideration request.
I have a statement. I truly take issue with someone making the accusation that I am treating women differently from men, which is what you just said, that the board is treating women differently from men based upon another board's opinion about an issue. There's been an effort to state that this is not about gender, but this is exactly what it is about, based on what I'm hearing this morning. And it's being turned into a gender issue for I don't know what reason. But for me, it was strictly based upon what the law says and what the facts are. So I would truly appreciate it if you do not direct your view that there's a bashing of women to me. Now, I can't speak for the rest of the board, but I really take issue with that because as you can obviously see, I'm a woman too. I'm a woman too. So if you want to create your issue, your political issue, your platform, or whatever it is that you want to do, that's fine. But I take issue when someone is making an accusation about me when that person doesn't know me, and I know it's not true. So I value your opinion, and if that's what you believe, fine. But I just need to make a statement. I don't know what the rest of you, how the rest of you feel, or if you're going to say anything, but I'm really getting tired of being accused of being someone who is against females running for office and being empowered, because I'm very supportive of my fellow females and all that they want to do.
Okay, and I can absolutely appreciate that, and I would just like to say that regardless of intent, sometimes decisions have consequences regarding gender, regardless of intent. And that being said, previous iterations of this board have okayed male candidates requesting that childcare be considered as a campaign expense by not flagging them for ethical violations. And I realize that you are not bound by precedent, but I am just asking you to consider that previous versions of the board who have the exact same job that you have, and the law has not changed since they made those decisions, that their expenses were covered. That is all I am asking you to do, to consider those things. Thank you so much for your time this morning.
Ms. Davis, the earlier opinion requested by Mr. Orso listed 3 specific questions. The original request by Ms. Lamandre was, please tell me what anybody can use campaign funds for regarding child care. Wide open. There's no way in the world we can answer those questions. But we understand the issues. We understand what y'all are talking about.
But, and I know you keep saying that, you know, my letter said in what instances. So it also talked about, and I know that the irrespective test is not part of state law or anything, I mentioned that these expenses would not occur except for my campaign. So rather than turning the precedent and saying, overruling the prior precedent, which I know you're not bound by precedent, and saying it's a personal use, the board could have said, well, in very specific situations, for instance, fundraisers, panels, those things, that's how the board could have answered the question instead of just outright saying it was personal use.
Okay, but do you understand what you're doing? We cannot provide an exclusive. The list that we would provide would not include every possible scenario for which campaign funds could be used regarding child care. It's just almost unrealistic to think that we would be able to give you an itemization of possible uses.
And I know
that's why I think having a revision or an amendment to the legislation would definitely help in a situation, especially a situation such as this.
I'm sorry that this is affecting you so personally. No,
you're not going to do that. It's not affecting me personally. It is affecting me in the sense that we still have the same law on the books. We still have no changes in those laws. We have not been, I have not seen where the facts in this case are similar to the facts in the FEC case, for instance. Because I was really trying to find a way where I could apply what was held in the FEC case to this case. And I just don't see it. And then now I'm hearing it's not a gender issue, but everything I'm hearing is that it's based on gender, and that's not fair. That's not fair because we are bound by the law. We're bound by the law. And we're being attacked because we're trying to apply the law as it is currently written.
I don't think anyone is trying to attack the board. I think, as my friend pointed out as one of the first speakers, as somebody outward looking in, that's what it looks like. It doesn't mean that's what is actually happening. It doesn't mean your intent is to discriminate. It's about what it looks like as an ordinary citizen looking in. That's what this is about.
Ma'am, I'm concerned about the consistency aspect of things that has been suggested during this hearing. I come from a criminal lawyer's background, and I rely a whole lot on prior court decisions. But you surely aren't asking us to go along with something that we feel and we interpret differently than some prior board. As you know, the law changes. As time goes on, we see mistakes that we've made in the past, and we do what we can to change those things to make the system better. Surely you would support that.
I don't support that childcare is all of a sudden something that is prohibited under the law. If you look at the law, if you look at what everyone has discussed about how the precedent of the First Circuit is, I don't believe that the child care issue in this case, which is campaign fundraisers, canvassing, things that I am only doing as a result of my campaign, things that are outside of the normal child care hours that I have, I am saying that no, it does not make sense. I do not agree that this is making things better. If anything, it's taking a step backwards, because now multiple states, the FEC, and I know that no one really cares about those other things, but it is us taking a step backwards, as we had it before and now all of a sudden we're saying it's not okay. I don't believe Louisiana needs to take any steps back. In fact, I think we need to do everything we can to move forward.
Your choice of words bother me also in this particular instance. You said all of a sudden.
All of a sudden with this new request that I put in, and you guys made a different decision. It's not me trying to be manipulative or be charged in my language. I'm just saying what has happened.
Thank you.
Ms. Deborah, next name.
Julie Harris.
Good morning. My name is Julie Schwam Harris. I'm from New Orleans. I'm a retired, longtime city administrator in the city of New Orleans. And over the past 10 years, I've been pretty active as a citizen advocate. I do work on issues related to women, but I really interpret this a little bit differently. So I'm hoping that what I will bring, and it'll be brief, answers some of the questions other than the gender issues around this. I appreciate that you are reconsidering your decision from before to about the appropriateness of having child care costs related to the campaign being allowed. I hope you will use the power and the precedent that you have, because I think you do have the power to do this, despite the way the law is written, or perhaps because of the way the law is written, and to establish, reasonable but relatively broad parameters within the law, as it was stated by the gentleman earlier, to allow the policy to cover appropriate child care expenses. My rationale is that we as a society benefit from people of all walks of life, all genders, all incomes, all races, being a part of the political system. And I think structurally it's been hard for people from all these walks of life. I mean, I'm not saying that no one with low income has never been elected, or no one that's a woman has ever been elected, but I do believe that some of the structural barriers to access the political system as an elected official have made it harder. And so if it's within your power, and I believe it is, at least I hope you think it is, to do this at this time, I would urge you to make a broad decision that fits within the parameters of the law to allow this. I do understand the desire to have that law perhaps clarified, and I'm a volunteer advocate. I am happy to support any clarification that is brought that I think does what I believe you have the power to do, but you would feel more comfortable and certainly more reassured, against any future court action to do. So I'm asking you to rule today to allow this use of childcare within some sort of parameters that you could state, and I know I don't know your business, but somehow state within your ruling that would make it seem like reasonable parameters, and then and as you have publicly asked for a statutory change, maybe put that in writing to the legislature, and again, I will volunteer to help get that change. Thank you.
Thank you, ma'am. That's all? So you have those about a dozen of them on there. You got them?
I mean, I do, but they're here for different docket numbers.
Oh, okay.
Those are everyone.
Anyone else have comments? Last chance. All right, any board members, any comments?
Yeah.
Bruno?
I think Ms. Roberts has very eloquently stated the reasons why this board does not have the authority to do this. This is an administrative board established by the legislature. It is not a policy-making board. Policy is something that should be set by the legislature. I spent 32 years of my life jealously guarding that right of the legislature to be the one who makes the policy instead of an administrative board. It has been admitted today, at least in the testimony, and certainly as buttressed by Ms. Roberts' comments, that we are being asked to make law. It is simply not our function. It is the legislature's function. And some of the documents that I have read, it was said, well, there's no time because the laws won't go into effect until August 27th. Well, the Constitution of this state says that you can put an immediate passage clause in the legislation. The bill would become effective upon signature of the governor, or you could set an earlier or a later date for the effective date of the legislation. And I just wanted to correct the record with respect to that argument, because that argument doesn't hold any water. So that's basically what I have to say. It is a limited function. It's not our function to make law. If it was our function to make law, I think you'd see a lot of changes in the ethics code, in the personal financial disclosure reports, where we have to get a report from towns that have 100 and some odd people in them and 3 aldermen that have a constituency of less than 100 people. But we can't. We do not have that authority. And that's what I think this is. I think you're in the wrong forum. And if you want to go to the legislature and get something done, then we will apply it. That's all I have to say.
Anyone else? Yes, sir.
I just want to say that I'm in complete agreement with the idea, and I wish the legislation we're currently working with was clearer. I'm a pediatrician, and I very much feel that this is an important subject. And I also recognize that life, people, and legislation evolves. We have numerous opportunities on this board to see situations that are not clearly covered under the law. And it's very frustrating for me, not a lawyer, to be hamstringed by not being able to. This is obviously inappropriate and doesn't apply in this situation, the law. But we can't just ad hoc adjust it. Thank you.
Anything else?
May I say something? I was not on the board when the decision was made. Had I been on the board, I would have voted in your favor, and I'm prepared to do that today. So if somebody make a motion, I'd like to make a motion to allow Ms. Lamandre to be able to use campaign contributions for babysitting duties while in the course and scope of campaigning for whatever office.
There's an existing opinion that says she can't. So do you have a motion to withdraw that opinion, the original opinion?
I have a motion to withdraw that opinion.
We have a second to that motion. Second from Mr. Detmer. Any objection?
I object.
Call the roll, please.
Mr. Bruno?
No.
Mr. Colomb?
Yes.
Ms. Kuvion?
Yes.
Mr. Dittmer? Yes. Father Lavastida?
No.
Dr. Leggio?
Through the rest of this. Made up my mind.
Is that possible? Can he postpone his vote to the end?
I think he needs to vote, but if he wants to abstain from the vote, or
I think you have to either vote or abstain.
Okay, I abstain.
Okay. Mr. McAnally?
Yes to the motion.
Dr. Minor?
Yes.
Ms. Roberts? And Mr. Smith? No? Is that a no?
All right, the motion to withdraw the prior opinion has passed my vote of 5-4. Mr. Colon, you had a motion to
motion.
How would you can you word it? Can you articulate your motion?
What I would do would use the language in the prior opinion to say you can use campaign contributions for these particular in these particular circumstances, whatever that wording is. I don't have it in front of me.
May I propose, Paul, an amended motion to your motion?
Say again?
May I propose an amendment to your motion?
Sure.
I would move that the board adopt the opinion that the Campaign Finance Disclosure Act does not prohibit the use of campaign funds to pay child care expenses that exist solely because of a person's participation as a candidate and which would not exist but for her campaign.
Second.
Motion seconds. Everybody understand the motion? And we have a second to it. Who seconded it? Second. John. Any discussion?
Well, I just think we're right back where we were. And this board is not a lawmaking body. And that is exactly what you all are doing. You are making laws. And it is not our function.
It's our
Don't have excuse me?
It's our role to interpret and apply the law.
You know, may I finish, please? You do not have unlimited authority to do that. It has been said that the law is vague. The law is vague. Where do you clarify the law? You don't clarify it here. You collect it down the street. So I object.
Dr. Martin, do you have a comment?
I think we're ready to vote.
So there's an objection to the motion. Ms. Deborah, would you call the roll, please?
Mr. Bruno?
No.
Mr. Colomb?
Yes.
Ms. Kuvion?
Yes.
Mr. Dittmer?
Yes.
Father Lavastida?
No.
Dr. Leggio?
Yes.
Mr. McAnally?
Yes.
Dr. Minert?
Yes.
Ms. Roberts? Mr. Smith?
Can you speak into the mic? I'm sorry.
No.
The vote is 6-4. Motion passes.
Thank you. Thank you so much.
Staff will put together issue an opinion consistent
Yeah,
with
please,
that motion
please present it and present it to us for consideration.
at the next board meeting,
Before
sending it out.
we will send it out, yes.